Welcome to Tech Law Today. I'm Doug Hammond, and today we are briefing Van Buren versus United States. Well, really deep diving to the whole majority opinion. So let's go. The Supreme Court decided Van Buren on June 3rd, 2021. Justice Barrett wrote for the majority, and Justice Thomas dissented, and he was joined by Chief Justice Roberts and Justice Alito. The court analyzed whether Nathan Van Buren, a former police sergeant, violated the Computer Fraud and Abuse Act, the CFAA, when he ran a license plate search in a law enforcement computer database in exchange for money and in violation of his department's policy. Given that the CFAA makes it illegal to access a computer with authorization and to use such access to obtain or alter information in the computer that the accessor is not entitled so to obtain or alter. The Supreme Court held that Van Buren did not violate the CFAA, concluding that the statute covers those who obtain information from particular areas in the computer to which their access does not extend. It does not, however, cover those who, like Van Buren, have improper motives for obtaining information that is otherwise available to them. The Supreme Court reversed the judgment of the 11th Circuit and remanded the case. This all started, the act in question, it occurred during an FBI operation investigating then Police Sergeant Nathan Van Buren. During the investigation, an acquaintance of Van Buren's, acting as an FBI informant, asked Van Buren to search the police database for a license plate. In exchange, he promised to pay Van Buren $5,000. Van Buren used his patrol car computer with his valid credentials to search the plate in the database, knowing his search breached department's policy because he had been trained not to use the database for an improper purpose, and that was defined by the policy as any personal use. Well, after obtaining the license plate information, Van Buren told the informant, "Hey, I have information to share," and this allowed the federal government to then charge Van Buren with a felony violation of the CFAA. Van Buren, he was convicted by a jury in the Northern District of Georgia. He appealed to the 11th Circuit, where the 11th Circuit upheld the trial court's decision. Van Buren, he argued that the exceeds authorized access clause of the statute applies only to those who obtain information to which their computer access does not extend, and not to those who misuse access that they otherwise have. Well, several circuits agree with Van Buren and see it his way. Some other circuits, including the 11th, have taken a broader view, and they create liability for those who misuse access that they otherwise have. The Supreme Court of the United States granted certiorari in this case to resolve the split in authority. Let's start with the law. The Computer Fraud and Abuse Act places criminal liability on those who intentionally access a computer without authorization or exceed authorized access and thereby obtain computer information. It defines the term exceeds authorized access to mean to access a computer with authorization and to use such access to obtain or alter information in the computer that the accessor is not entitled so to obtain or alter. The key phrase here is exceeds authorized access, and that means to access a computer with authorization and to use such access to obtain info in the computer that the accessor is not entitled so to obtain. Here, the parties only dispute whether Van Buren was entitled so to obtain that license plate info. Now, entitled, that means to give a title, a right, a claim to something. So Van Buren wasn't entitled to obtain the plate info in that he had been given the right to acquire it from the police database. But was Van Buren entitled so to obtain that plate information as the statute requires? Well, Van Buren argues is not entitled so to obtain refers to information one is not allowed to obtain by using a computer that he is authorized to access. For example, if a person accesses an info in say folder Y, and he could permissibly pull information from folder Y, then no violation occurs by obtaining that info, regardless of whether he obtained the information for a prohibited purpose. But if the information is located in prohibited folder X, to which he lacks access, then he obtains that info from folder X, then he violates the CFAA. On the flip side, the government argues so more broadly, and that is not entitled so to obtain refers to information one was not allowed to obtain in a particular manner or circumstances in which he obtained it. The manner or circumstances are defined by any specifically and explicitly communicated limits on one's right to access information. Government relying on ordinary meaning argues that Van Buren exceeded his authorized access to the database when he obtained the plate info for his personal purpose. Under the government's example, an employee might lawfully pull information from folder Y in the morning for a permissible purpose, but then unlawfully pull that same information from folder Y in the afternoon for a prohibited purpose. The Supreme Court agrees with Van Buren because 1. So typically represents a word or phrase already employed. 2. Access is a technical term. 3. Van Buren's consistent application of the two ways one can unlawfully obtain info aligns with the design and structure of the statute. And finally, 4. Both the statute's history and policy implications align better with Van Buren's interpretation. So let's start with 1. The government's reading of so captures any circumstance-based limit appearing anywhere in the United States Code, a state statute, a private agreement. The circumstance under the government's reading is not defined by a word or phrase already employed earlier in the statute. And this is not the correct reading because the relevant question is not whether Van Buren exceeded his authorized access generally, but whether he exceeded his authorized access as the CFAA defines that phrase. 2. When interpreting statutes, courts must take note of terms that carry technical meanings. Access is one such technical term. Further, when a statute includes explicit definition of a term, as it does here with exceeds authorized access, the court must follow that definition, even if it varies from a term's ordinary meaning. So, access references the act of entering a computer system itself, or a particular part of a computer system, such as files, folders, or databases. And thus it is consistent with the meaning to equate exceeding authorized access with the act of entering a part of the system to which a computer user lacks access privileges. 3. Without authorization and exceeds authorized access clauses of subsection A2, the CFAA, offer two ways of obtaining info unlawfully. Van Buren argues without authorization protects computers from outside hackers, those who access a computer without any permission at all, and argues exceeds authorized access is protecting computers from inside hackers, those who access a computer with permission but then exceed their access by entering an area of the computer to which their authorization does not extend. With Van Buren's reading, liability under both clauses stems from a gates up or down inquiry. One either can or cannot access a computer system, and one either can or cannot access certain areas within that computer system. On the other side, the government argues without authorization as a gates up or down inquiry, like Van Buren, but then reads exceeds authorized access as one that depends on the circumstances incorporating a purpose-based limit contained in contracts or maybe workplace policies, as is here. The court says the government's reading has problems because treating the access in the two clauses differently is inconsistent with subsection A2's design and structure. And the government doesn't explain why the statute would prohibit accessing computer information, but not the computer itself for an improper purpose. Also, the government's reading doesn't really align with the statute's definition addressing damage and loss for civil liability, but that's another thing. 4th, the CFAA's statutory history also weighs in favor of Van Buren. When Congress amends legislation, the courts presume that it intends the change to have real and substantial effect. The precursor to the exceeds authorized access clause alluded to in an earlier part of, or a former part of the statute, it alluded to the purpose of an insider's computer access. However, the current CFAA makes no mention of purpose in defining exceeds authorized access. The majority then presumes the real effect Congress intended was to remove purpose-based liability. Finally, policy weighs in favor of Van Buren as well. The government interpretation of the statute would attach criminal penalties to a breathtaking amount of commonplace computer activity. If the exceeds authorized access clause criminalized every violation of a computer use policy, then millions of otherwise law-abiding citizens would become criminals. Take the workplace. An employee sends a personal email or reads the news from her work computer. Or let's take the internet, for example. A person embellishes an online dating profile or uses a pseudonym on Facebook. They would all be facing or could be subject to criminal liability. So, In conclusion, an individual exceeds authorized access when he accesses a computer with authorization, but then obtains information located in a particular area of the computer, such as files, folders, or databases that are off limits to him. Van Buren accessed the law enforcement database system itself with authorization, and Van Buren had access to the system to retrieve license plate info. Therefore, Van Buren did not exceed authorized access to the database as the CFAA defines that phrase, even though he obtained that information from the database for an improper purpose. Whew! Done.